Hello, hello. It is Saturday, December 20th, 2025. And tonight we're going to explain what has been happening in my Illinois cases. This podcast has been pretty much covering all of my Florida Circuit 7 and Florida District 5 Court of Appeals. As of July of this year, I got myself back into Illinois Circuit 19 that started this chaos, and I'm now in Illinois District 2 Court of Appeals, so which is exactly where I wanted to be. Never go back to the people that were abusing you, that caused the drama. You take it up a notch. So that's what I'm doing, and that's what we're going to start explaining. So, Pete, I would like to start with the Florida appellant case, just so we can get this out of the way. And then we have a massive stack of documents to show you. This is all Illinois Circuit 19 and District 2 Court of Appeals. So I have 3 current cases in Florida District 5 Court of Appeals, and this one is on my 3rd of the 3. And so we briefly touched on this in episode 25, but Justin never responded to the initial brief with his reply brief. His appellee's brief. So like the other 2, I filed a notice of appellee's failure to file a reply brief by deadline. And so District 5 Court of Appeals in Daytona, Florida now knows that he did not respond. So this is basically me putting District 5 on notice saying, hey, I'm doing my part.
Time to move on.
Yep,
let's get this thing going.
Exactly. So that's all that's happened in Florida. I still have not put any motions in front of my new judge since Sandra C. Upchurch was moved off of my case and into Flagler County. She is no longer dealing with family law. Thank God.
Probably a good thing for a lot of families.
Yeah, absolutely. That woman should not be in charge of children's lives. So that's it for Florida. We're going to transition right over to Illinois Circuit 19 and Illinois District 2 Court of Appeals. So previously in episode 25, we covered everything up to October 26th. So October 31st, I did get a letter confirming that the docketing statement in the above cause has been filed. Pursuant to Illinois Supreme Court Rule 311A, the court has been ordered an accelerated due date listed below. So, Pete, you've now seen my cases in Florida District 5 Court of Appeals, and now you've seen how Illinois does appellant cases. What are your thoughts on this accelerated due date?
So it is something that makes complete sense whenever you have, if you have a case that's dealing with, children and custody and critical issues, and you don't have a means to accelerate it and get it moving, to get it taken care of in the best interest of the children, is kind of crazy. And that's how Florida is.
Yeah.
Illinois actually has specific statutes for specific cases. And so this case is a case involving child custody. So there's an accelerated docket. It basically nearly cuts the timeline in half for just when things have to be filed and when the lower court has to send stuff to the appellate court. And then presumably it would also accelerate the appellate court actually reviewing the briefs and, getting it, a decision on it.
Yeah, so the accelerated due date,
Which is,
this lists record on appeal with report of proceedings, bystander report, or agreed statement of facts is due November 24th, 2025. Now, because I've never been in Illinois appellant court before, I'm pro se, obviously. I'm learning as I go, trying to educate myself as I go. So I did not know that the bystander's report pretty much has to be done immediately. So the due date for the record on appeal and the bystander's report was November 24th, and this is dated October 31st. So I previously explained the bystander's report is if there is no verbatim transcript available, which, like a lot of our cases, especially in family court, there are no recordings, no transcripts of anything that is transpiring.
But, speaking of that, it's really interesting because that podcast we mentioned last week, they're in Kentucky. And apparently in the state of Kentucky, all family court hearings are at the minimum recorded.
Yeah.
And so there is a video that they call the record that you can request. It's interesting that Kentucky has it figured out, but Illinois and Florida are still, backwoods hicks, comparably speaking.
Yeah. So the podcast he's talking about is the Judgmental podcast with Christine Miller and Hugh from Louisville, Kentucky. And I'm almost caught up with all of their episodes. I love that podcast. So if you have not already checked it out, definitely check it out. They only cover stuff in Louisville, Kentucky. They're not covering everything nationally, but it is definitely interesting to hear two attorneys.
Yeah, they're both former practicing family law attorneys. Both of them have left family law practice, and they're working on trying to get some, light shown on the family court system, and some of what they have dug into on the first couple episodes that we've listened to is just, some of it's like shocking. It's like, my God, we've already been talking about that.
Exactly.
Not to get too sidetracked.
Yeah. So a lot of the things that Christine and Hugh talk about are things that Pete and I have absolutely been talking about as I'm a pro se litigant. And so it's definitely neat to hear attorneys complaining about the exact same thing I am complaining about. So these documents, just like every other time I go through my documents, this is all going to be scanned in a Google Docs PDF. You can look at everything as we're going through it. So on November 16th, so remember, the bystanders report and record on appeal was due on the 24th. So on the 16th, I rushed to get this bystanders report typed up and served to Justin Serlick. Now, basically, the appellant writes their version of what they witnessed and what they went through, their recollection of what happened in the case. And then they send it to the appellee. And then the appellee is supposed to, within 14 days, send a response saying, no, I don't agree with this, I agree with that, this needs to be changed, yada, yada, yada. And then you submit the adjusted bystanders report to Illinois Circuit 19 to be certified by the judge. Well, not only was Justin served with the bystanders report, but just to cover my bases, his previous attorney, Will Treberis, of Katz, Goldstein, and Warren in Bannockburn, Illinois, also received a copy of the bystanders report on November 16th, to which both of them completely ignored me. So that bystanders report, I've plastered all over my social media prior, but it'll be in this massive document file for you to look at. It basically gives the entire breakdown of what happened from 2020 to current, how my children ended up in Florida, and how Justin Serlick has been continuing to hide them behind this void ab initio 3-page ex parte order that's highly illegal. And I'm calling everybody out on it. So because I realized I did not get the bystanders report filed quickly enough, I filed for a motion for extension of time in the appellate court, District 2 in Elgin, Illinois. And so that was a motion for extension of time. And it basically said Appellant Heather Bendel has confirmed with Illinois Circuit 19 that there are no recordings of any of the Zoom hearings from September 15th, 2020 to the last hearing, October 8th, 2025. Therefore, Heather Bendel has filed a bystanders report with the opposing party November 16th. And the opposing party has 14 days to respond, which is past the current deadline of November 24th for the record on appeal. With a reported proceedings, bystanders report, or agreed statement of facts. Appellant Heather Bendel is respectfully requesting a 30-day extension to the November 24th, 2025 deadline to have all subsequent deadlines toll. So I got that filed, served it on everybody. Justin never objected. And so I got a letter. Where is it? I think it's... Okay. November 25th, I got a letter from Illinois Appellate Court, 2nd District. The court has this day, November 25th, 2025, entered the following order in the above entitled case. Appellant's motion for an extension of time to file the record on appeal is granted. The record on appeal, including a certified bystander's report, is due December 24th, 2025. So thank you. They gave me that extension to allow me to go through the proper procedures, because as a pro se litigant, I did not know I needed to get that bystander's report done immediately. So if you are in the state of Illinois and you are in a similar situation to me, where there are no transcripts, no recordings, nothing on the record to prove what these judges are doing to your family, if you are able to get your case into appellate court in Illinois, just remember that you have the opportunity to get your bystander's report on the record instead, or agreed upon facts.
If you can get the judge to sign off on it, which we'll get into that.
Yeah. That's pretty much what this whole stack is the judge, Judge Jacqueline Melius, walking all over my constitutional rights.
Also just making flat out incorrect legal judgments.
Right. So at the same time that was going on November 20th, I got the invoice for the record on appeal. Now, previously in prior episodes, I had explained the hell I went through in June of 2025 just trying to get a fee waiver to get a certified copy of my Illinois docket for my Florida appellant case. This was before I filed a petition for relief and vacatur in Illinois. And I was abused by Judge Sharmila Manis of Illinois Circuit 19 for 45 minutes in June.
And it wasn't even just you. She questioned me on my income, and I'm not even a party to the case. I was just sitting next to Heather in the office when we were on the Zoom.
Yeah, he has nothing to do with my case in Illinois.
And this judge in Illinois was trying to say that my income is somehow relevant, and it's truly not. But
yeah. So I decided after that insane, and it's recorded, that insane situation with Judge Sharmila Manis in June of 2025 in Illinois Circuit 19, I decided I was not going to deal with the fee waiver, and I was just going to pay the fees. So to give you an idea, my Illinois docket is nowhere close to the size of my Florida docket. And so on November 20th, I get an invoice for record on appeal. Payment must be e-filed along with a letter. You may access e-filing through LakeCountyCircuitClerk.org. When paying, please select all the following marked options located under optional service and fees. And $100 is checked, which is under 200 pages.
So basically, it's $100 for the first 200 pages of the docket.
And then any amount of pages after that are 25 cents a page. So total amount for my record on appeal to get over into Illinois District 2 Court of Appeals without a fee waiver or indigent status, $346.25.
But wait, there's more.
So it's kind of strange. You have to file a correspondence letter in order to get the fee paid. So I typed up this correspondence.
It's like you have to write your own invoice and file it back to the court.
Yeah.
Just
so
to pay.
you then e-file it and
backwards.
You pay the fee. So yeah, for the first set of my record for Illinois Circuit 19 to send over to Illinois District 2 Court of Appeals was $346.25. So that was done and taken care of on November 21st. And so now we're on December 1st. Justin Serlick never responded to my bystander's report. And so I knew this wasn't really going to get far, but it gave me an opportunity to get my bystander's report on the record in Illinois District 2. So in appellant court in District 2, I filed a motion to compel appellee Justin Serlick to complete the bystander's report. And so I basically said he was served, his attorney was served, they're ignoring me, blah, blah, blah. Can you please send a letter to him saying, hey, can you get this done? For that, I got what I kind of expected, but hey, it was worth a shot, right? If you don't ask, the answer is always no.
And we were actually told to do this by one of the court clerks in one of the courts. I forget which one.
Well, they can't give legal advice. They can just kind of say, hey,
Here's some ideas.
Exactly. Here's an idea. Look into it. So on December 1st, I believe it was the same day I e-filed it, this court, this is from Illinois Appellate Court, 2nd District in Elgin. This court has this day, December 1st, 2025, entered the following order in the above entitled case. Appellant's motion to compel appellee to complete bystander's report is denied. Illinois Supreme Court Rule 323C states within 14 days after the service of the proposed report of proceedings, any other party may serve proposed amendments or an alternative proposed report of proceedings. Emphasis added. Appellee is not obligated to respond to appellant's proposed report of proceedings. But by not responding at all, what does that mean?
It's basically an agreement with the document.
It's uncontested. He didn't argue what I said.
Because it was uncontested, what should have happened when Judge Melius, when you filed a motion for her to certify it, really, she should have just certified it when it was sent to her. Yeah. But you had to file a motion to get her to certify it and schedule a court date. Yeah.
So that's the next document here. December 1st, I filed, because to get it in front of her, you have to motion it up. So I filed the motion. The title of the motion is Motion to Certify Bystander's Report Without Hearing, because we don't really need a hearing. The appellee did not argue.
It was uncontested.
It's uncontested. He didn't argue it. We don't need a hearing. We do not need to waste taxpayers' money.
Not present in court. His attorney, who had represented him in the lower court, was present for that, but informed the court that he was not representing Justin in the appeal. So he was going to turn his video off and not take part in that particular court hearing that, or court meeting, whatever you want to call it, that morning via Zoom.
Yeah, the Zoom hearing where at least 15 of my court watchers were denied, and then We the Parents Foundation put out a lovely, thank you, Crystal, for that, a lovely notice of Judge Jacqueline D. Melius multiple times, 4 times in total since August 12th, blocking all of my court watchers across the nation, even though the Zoom link is on the public page for Illinois Circuit 19 that anybody can click into whenever they want. But apparently it is not available to the public. So with that motion, you also have to file a notice of court hearing, because in Illinois Circuit 19, now all courts are different, but for Illinois Circuit 19, you have to call the judge's clerk and have the judge's clerk put you on the schedule.
Let's make the system as inefficient as humanly possible.
Right.
And that's what they did in Illinois.
Yeah. So here's the motion. I had the bystander's report in there, evidence that Justin and Will Traberas were served with it, even evidence that Justin Serlick received the USPS tracking. Your item was delivered to an individual at the address at 2:57 p.m. on November 19th at Daytona Beach, Florida, 32114. The item was signed for by J. Serlick. So that was the bystander's report. So not only was he e-served, directly emailed, but it was also physically mailed to him with tracking that I have evidence that he got it in all 3 forms. So along with that, you have to file the notice of a court date for motion. So Iris Salcido put me on Judge Melius's docket for December 9th at 9 a.m. in courtroom 105, and that was the hearing where none of my court watchers could get into. So that's, that was all served together. Justin Serlick did not show up on December 9th. So when I was putting this packet together, I actually just noticed something tonight that is very interesting that I want to call out, because in previous episodes, I've pointed this out. In Illinois, I have now gone through 6 judges since 2020, not because I'm disqualifying them.
Nope.
Not because I'm ordering them to step away from my case.
No, it seems like, you want me to say it?
Go ahead.
When they realize they fucked up, sorry for my language. Hold on. When they realize they they just step aside, reassign it to another judge, and then when you're in front of that judge, they like to sit there and, play the game of, well, I didn't see it. I didn't hear it. I can't talk about it.
Yeah. Yeah. So this is the minutes for December 9th, which is missing information, Judge Melius. It says, present in court, Heather Bendel, appellant, petitioner, present via video. Doesn't mention Justin at all. It doesn't even say he wasn't present. Now, it does say in her order that he wasn't present, but the minutes should say appellee/respondent, Justin Serlick, was not present and not represented by an attorney. And then at the top right corner, and like I said, you'll be able to view these documents in its entirety in the Google Doc link. Event type, presentment of contested motion.
Wait a second. Who contested it?
There's no one contesting anything.
It was uncontested.
Where did that title come from? To reassign to C401.
So
I just saw this tonight.
It looks like it was reassigned potentially to another judge. Heather won't know until she tries to file something again, but I think we're possibly done right now with Circuit 19 for a while until the appellate court moves.
Yeah. So it almost looks like to me, after 4 hearings with Jacqueline D. Melius and me just flat out kicking and screaming, you're violating my constitutional rights, you're violating my due process, you're violating laws in Illinois and in our country. And I just kept calling her out on the fact that she was blocking my court watchers. I think she stepped away from my case because I'm on to her.
Not even just blocking
I've told her, I haven't threatened her. I have promised her that she will be a defendant in my U.S. District Court for 42 U.S.C. 1983, 85, and 86. So
civil rights violations.
Yeah. So I'm thinking
in federal court.
If this is what I think it is, I think on December 9th, she quietly stepped away from my case because I was promising her that I'm going to take her to federal court and point out everything she's doing to me.
Yeah, and I'd like to point out, it's not just that she didn't allow in court watchers, but she participated essentially in ex parte communications by booting you into the Zoom waiting room so you couldn't even hear what was going on.
Yeah.
She would refuse to let you speak and just, put you on mute.
Kept muting me.
None of it, the hearings had to turn the way they did. If she would have, in every hearing, you always prepare, you have a generally a prepared script that you request permission to read. And the reason you request to read from a script is because you have a documented ADA disability.
Well, multiple. This court has also kidnapped and trafficked my children and put a gag order on me for 3.5 years. So they are my abuser. I absolutely have complex PTSD because of Illinois Circuit 19 and these judges that are working for the Serlick family. So not only do I have an ADA accommodation federally protected for my hearing impairment. I was born deaf in my right ear, but I also have ADA protections for my trauma that they have inflicted on myself and my children for the last almost 6 years now. Because we're halfway through December, and January will be 6 years that this saga has been going on.
Yeah, so for anybody out there that doesn't know, as part of the Americans with Disabilities Act, if you're a victim of something that gives you, PTSD and you have a court, you can actually request accommodations. One of the most common accommodations is what they call CART services, which is typically, in Heather's case, because she's deaf in one ear, CART service is basically a live transcription. But with a lot of people who suffer from PTSD, we found out that just having CART services, giving you something to focus on during the hearing, actually helps you a lot. Yeah, and
like being forced to sit next to my rapist, Justin Serlick. It gives me the ability to focus on the screen instead of him.
So Circuit 19 in Illinois, I want to point out, Heather has brought this up almost every hearing, I believe. And at no point have they truly acknowledged it, other than in the last hearing, they did let her read her statement and they acknowledged why they were doing it. But they've never sent any rules or instructions if Heather has to request anything else, as opposed to here in Florida. Florida, anytime you get served with anything from the court, they have a standard sheet that they're including with everything that says, if you need any accommodation, call this number and they'll take care of it.
Yeah.
Illinois
likes to protect themselves.
They're backwards.
Yeah. So then on top of the minutes, that top right corner notation is interesting. So we shall see if my prediction is correct. But then she decided to file a 3-page order.
They like those 3 pages.
Which is basically her recollection of and her version of a bystander's report, since she refused to certify mine. So it says, this matter coming to be heard on December 9th, 2025, pursuant to Petitioner Heather Bendel's motion to certify bystander's report without hearing. Heather Bendel appearing via Zoom. Justin Serlick, respondent, not appearing, despite being emailed notice of the hearing date via email on December 1st, 2025. The court being fully advised in the premise, due notice having been given, it is hereby found and ordered. Found and ordered? Wait, but Melius, I thought you weren't around for the whole last 5 years. So how can you find and order that this is what happened in my case?
Oh, we're just going to find that your case only existed in the last 2 court dates.
Oh, yeah. So the 3 years prior where you kidnapped my children.
Never happened.
Slapped a gag order on me.
Don't know about it.
And then trafficked my children all over the state of Illinois through private for-profit Camelot
That
care.
was a different judge.
And then Kathleen McGee, guardian ad litem from Vernon Hills, Illinois, sold my children to the non-custodial parent.
That was a different judge, and even though they're in the same courthouse still, we can't talk to them.
It was a figment of my imagination. All right, so it says,
ridiculous.
Findings. This case was called at 9:43 a.m. to allow both litigants adequate time to appear in court. Justin Serlick did not appear in the Zoom courtroom. Will Traberis, Mr. Serlick's prior counsel, was in the Zoom courtroom on an unrelated matter and advised the court and Ms. Bendel that it is not Mr. Serlick's attorney. That's not even proper grammar. That is not Mr. Serlick's attorney in any appellant-related issues. Ms. Bendel requested to read a statement to the court in its entirety, which the court allowed. The statement detailed why she was appearing in court and detailed what she was seeking. Heather Bendel represented that she served her proposed bystander's report on Justin Serlick on November 16, 2025. Ms. Bendel represented that she did not receive a proposed bystander's report from Mr. Serlick, nor did he offer any amendments on hers. The court has not received any reports from Mr. Serlick either. After Ms. Bendel spoke, the court advised Ms. Bendel that the court was going to speak. Specifically, the court advised that only the bystander's report it was reviewing was the portion related to the October 8th, 2025 proceedings pursuant to Supreme Court Rule 323.
But that's not what the rule says.
Exactly. Ms. Bendel repeatedly interrupted the court while it explained its observations. That was me correcting her, saying,
trying to object.
No, ma'am, because I will not call her Your Honor. You are inaccurate, and that's when I kept getting muted. And, of course, there were no court watchers, so no one witnessed any of this.
Other than me.
Ms. Bendel repeatedly interrupted the court while explaining its observations of the report, specifically noting that it contained many court dates. Yes, it's got spots for many court dates. There's even an additional page that I had to put in to list all the court dates.
Because the prior hearings matter. Ultimately, you're ultimately... Your argument is that something that happened at one of those prior hearings was illegal.
Yeah.
And
April 27, 2022.
The court needs to wipe it away as if it never happened.
But that's not what the Serlicks want.
There needs to be some level of a record for that.
That's not what the Serlicks paid for. The Serlicks paid for that 3-page order to hide my children. Mm-hmm. Specifically noting that it contained many court dates, many of which did not involve this court, some dating 5 years back. Yes.
They like to...
That's the point of the bystander's report.
The way she words that, it makes it seem like this stuff didn't happen in Illinois Circuit 19. Let me be clear. All of this happened in Illinois Circuit 19, Courtroom 105, just because they changed the judge doesn't mean it didn't happen in that court.
Right. And that goes back to every time the judge does something nefarious and illegal, they dip out and assign a new judge. So the new judge is like, I don't know what's going on. I'm not going to sign that bystander's report because that didn't happen under me. I know you guys are dealing with this in other courts. There's no way I'm alone in this, where judges just dip out and then all of a sudden you have a new judge and then all of a sudden you're starting fresh.
As soon as you call them out on something, all of a sudden they're nowhere to be found, and you have a brand new person that you have to start all over again,
explain what's going on, and then they're like, well, I wasn't here for it, so I can't rule on that, blah, 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 blah. Yeah, this is the lovely kick the can down the road game that I was talking about in the last episode, 25. The court asked Ms. Bendel not to interrupt, and Ms. Bendel was not interrupted while giving her statement. Okay. The court reminded Ms. Bendel that she was not present for the hearing on October 8th, but I was. Specifically, Ms. Bendel had been ordered to appear in person on October 8th, 2025 for hearing.
That was after the court, in the actual prior hearing that Heather was in, the court said she could appear via Zoom.
And it's only because Will Traberis was arguing it wouldn't be feasible for Justin to fly to Chicagoland.
So the court agreed that both Heather and Justin could participate in the October 8th hearing via Zoom. And then randomly one night, there's a blank email that Heather happens to get and open.
1 week before this October 8th. It's dated September 2nd, which was the date that they said both parties can be via Zoom because they're in Daytona, Florida.
But that's not when it was sent.
But it was actually emailed to me by Iris Salcido in a blank email with not even a subject line, which is in no way, shape, or form considered serving someone.
Yeah, there's actually, in both Florida and Illinois,
like
there's
September
rules
23rd
about
or something like that. Literally a week before the hearing.
There's actual rules about when you're actually doing legal service via email, how things have to be structured, formatted, titled, and subject lined.
Right.
And a blank email with a PDF attachment doesn't cut it.
No. So, let's see, where were we? When Ms. Bendel appeared via Zoom, the court asked if she would like a new date so that she would appear in person. Ms. Bendel advised the court she would not be appearing in person as she believed Chicago to be a war zone. I never said
those
that.
words were never used. No.
Never said Chicago was a war zone.
That it was a dangerous area.
I did say repeatedly, and it's recorded, repeatedly, that I do not feel safe in the Waukegan, Illinois courthouse. These judges and these people kidnapped my children, trafficked them all over Illinois, sold them to the non-custodial parent who is their abuser on the record in police reports from my children's mouths, from the mouths of babes, on the record abuser to them, and then slapped a gag order on me. If they're willing to do all of that, what's to say they're not going to slap me with some bogus bullshit contempt order and slap handcuffs on me October 8th of 2025 and hold me in contempt at the Lake County Courthouse in Waukegan, Illinois?
And that was one of our big concerns when Heather got this random email one night.
It was a setup.
That was
the first thing that came to my mind. This is a setup. They're trying to set me up, to shut me up, to put me in jail. And you're not shutting me up. And then the second thing that I did say to the judge was that it was all over the news that ICE raids were happening in Chicago. It's a very well-known national fact.
It was on CNN, Fox News,
all
MSNBC.
over the news.
It was on every channel that we
O'Hare Airport is right next to the city. That's where I'd be flying in at. I don't need to, if you're ordering me in person, number one, I got to take time off of work. I have to request for a substitute, because I'm a public school teacher. So that doesn't exactly make it convenient for me. Number three, why was Justin allowed to be in Zoom, but I was ordered in person?
Yeah. It's unequal justice.
No, not happening. So no, when I got that email, the blank email with not even a body in the email.
And there wasn't even.
I filed a response saying, no, I'm not coming in person, and this is why.
And there wasn't, in that order to be in person, there wasn't even an explanation. It was just, we're revoking Zoom privileges. You have to appear in person. But there was no explanation. And literally, again, at the very immediately prior Zoom hearing, it was agreed by all parties, including the court, that Heather and Justin could both appear via Zoom.
We've got all these whistleblowers across the nation that are being jailed for no reason in family court, where they don't have counsel, they don't have a public defender, they do not have due process, and the judge is acting as the attorney, the prosecutor, and the judge all in one. So no, I am not going to serve myself up on a silver platter in Waukegan, Illinois for you to throw handcuffs on me and lock me away in Waukegan. Not happening. They've already violated a plethora of my constitutional rights. Why would that be any different?
Yeah.
So I responded to that before this hearing, and I said, no, I'm not coming in person. This is why, this is why, this is why. And she clearly ignored it. And then number 11, as Ms. Bendel did not appear in person as ordered, and because of her continued interruptions, it's called defending myself. Mm-hmm. I'm pro se. I'm allowed to interject, and I'm allowed to stand on my rights. Ms. Bendel was placed in the court's Zoom waiting room. A September 2nd, 2025 court order put Ms. Bendel on notice that failure to appear in person would prevent her from being able to argue on October 8th, 2025. If I have to be in person, then Justin Serlick should have been in person. And Justin Serlick wasn't even in Zoom.
But something interesting that, the reality is, based on what you filed, you actually didn't have to argue anything.
No.
The judge had legal requirements on what she needed to make decisions on.
Yeah.
And she didn't do it,
No.
which is immediate grounds for reversal, as the lawyers say.
Yeah. A person would prevent her from being able to argue. Okay. The court reiterated to Ms. Bendel this morning, December 9th, 2025, that the October 8th, 2025 hearing was a summary hearing, not an evidentiary hearing, that proceeded without her being present.
But it can't really be a summary hearing if they actually discussed jurisdiction. That makes it a evidentiary hearing. And the whole issue was
trying to argue that Illinois didn't have jurisdiction to deal with my petition for relief and vacature
because Florida has jurisdiction right now.
Florida has had jurisdiction since
February
of 2022. So how did Illinois file this 3-page void ab initio order April 27th of 2022?
Calendar gets twisted up.
Yeah. So. Let's see. Ms. Bendel was advised that this court granted Mr. Serlick's 2-619 motion to dismiss under subparagraph A9 as this court relinquished jurisdiction to Volusia County, Florida on September 3rd, 2024 after a UCC JEA conference with Judge Warren.
So that right there is the problem. Mm-hmm. Because Heather filed a petition for relief and vacature of the April 27th, 2022 order, on grounds that order was issued when the court did not have jurisdiction. By Illinois law, Illinois statutory law, mm-hmm. the only thing the judge has to do at that point is not determine if the court has jurisdiction today. The court has to first decide if they had jurisdiction on April 27th of 2022.
Yeah.
And the judge did not do that. She completely ignored that fact and just basically said, we gave jurisdiction to Florida in September of 24?
3 years later. 3 years after they lost jurisdiction because neither one of us lived in the state of Illinois
But
anymore.
there's issues with that too. So I don't want to make anybody think that was proper procedure anyways. But yeah, no, the judge had a legal obligation to decide first if the court actually had jurisdiction to issue that April 22 order. Mm-hmm. And that's what the court should have decided, not that the court should not have decided, we don't have jurisdiction to hear this today.
Right. Ms. Bendel continued to interrupt the court while the court advised her of the above. She then began direct messaging the court via the Zoom chat feature. Yeah, because you're literally sitting there playing the mute game. I try to say, Your Honor, you're wrong. Your Honor, that's not correct. Your Honor, you can't do that. Mm-hmm. Blah, 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 blah. So what does one do when their First Amendment rights are silenced? You go to the next best thing, the Zoom chat.
It really did seem like this was just the judge getting pissed off because someone called her out on being wrong on something.
Well,
and
you know,
she was, I mean, she's very wrong on it.
When you do illegal things, expect citizens that are victims of you to call you out on your illegal shit. Not all of us are stupid. Some of us actually know the laws and learn the laws and stand on our rights.
When you've been in family court for as long as you have, you've picked up a couple things.
Court watching, guys. Court watch. You educate yourself on ways to stand on your rights. So, yeah, I literally started putting in the Zoom chat, you're violating my rights right now. You're violating my due process. You're continuing to mute me. This is what Illinois did. And then I literally because there were actually people still in there, I put in there that I was asking them to Google Justice for the Serlick children so they could see what was going on. What's up?
No, I just didn't want you to go too much further.
Okay. All right. And then submitted to the council. Okay. An order detailing the October 8th, 2025 court proceedings was submitted to this court by counsel for Justin Serlick, and this court edited the order to reflect what transpired in court. Yeah, handwriting. The age of technology and their handwriting notes and altering the truth. Number 16, the October 8th, 2025 order is the best record of what occurred during the hearing on October 8th, 2025. 17, this appeal involves a matter subject to an expedited disposition under Supreme Court Rule 311. That's the accelerated appellant case.
So these last couple points are the judge trying to throw a monkey wrench into the proceedings.
She's trying to fuck up my appeal. Intentionally fuck up my appeal. This appeal, I already read that. Supreme Court Rule 311A2 requires that the individual filing a notice of appeal in a child custody or allocation of parental responsibilities case shall, within 7 days, serve the notice of appeal on the trial judge who entered the order on appeal. No such notice was provided to the court.
Yeah, apparently filing a notice of appeal with the court is not sufficient to get it to the judge.
Apparently, you also have to physically serve it to the judge. But what does one do when you're half a country away because that same courthouse shipped the children like property to the non-custodial parent?
Yeah, so we had to do some research and come up with a solution
we'll explain
to deal
that
with
in
that.
this. No status date was ever set in the trial court because no notice was provided of the appeal. So it sounds like
they
want to know when you're filing a notice of appeal so they can fuck up your notice of appeal. That's what it sounds like.
It sounds like you have to tell them you're filing a notice of appeal so that they can schedule a hearing, but
a hearing for what?
Yeah,
what's the point?
Even if it's I mean, she said what, a status meeting or something?
Hearing, yeah.
Yeah, I mean, what are they going to decide? Okay, we have, to file the bystander's report or accept it.
Yeah. So I want you to actually go over this document. I think it's everything. Yeah. Okay. So this document is what I filed in response to that order, that 3-page order. That is her recollection of what occurred. I responded to it on December 15th. And it is titled Petitioner Heather Bendel's Point-by-Point Response to December 9th, 2025 Order by Judge Jacqueline D. Melius. So you go over that.
And the reason for this, even though it won't change anything with the trial court, it puts things into the record.
On the record. That's going to be sent over on the record of appeal. Absolutely. And there's 5 exhibits, Exhibit A through E, in this document.
So I'm not going to read everything.
No,
but,
just overview.
Some of the high points. So we literally, you responded, point by point. So, finding number 1, case was called at 9:43 to allow both litigants adequate time to appear in court. You acknowledged the court's previously practiced. However, there was over 15 court watchers that were not allowed to get into public access Zoom that were all denied by Judge Jacqueline D. Melius and her clerk, Iris Salcido. So that puts that on the record that there was court watchers that were not allowed in. Also, that this has happened every single hearing since August 12th. In fact, almost every hearing, Judge Melius has pushed Heather's case to the very end of the call, isolating her from the public eye, which makes it very obvious there's something nefarious happening here. Finding 2, Justin Serlick did not appear in the Zoom courtroom. Heather noted, for the record, the respondent's absence constitutes a waiver of objection to the proposed bystanders report. The respondent, Justin Serlick, has not been present for any of the hearings via Zoom since petitioner Heather Bendel has filed for petition for relief.
He hasn't been present for one hearing, not one.
Yeah, he did have an attorney from his original law firm was representing him for some of the prior stuff here related to this filing.
But where the hell is he?
Yeah.
You're hiding my children from me while stealing 60% of my teacher's salary, but you can't even grace us with your presence. Where the hell is he?
So this is an interesting one, and I want to bring this up because judges are supposed to know the rules. You would hope, and you would hope they know the law. Finding 3. Will Trabaris, who was Justin's attorney for the prior portions of this, advised the court he is not Mr. Serlick's attorney in any appeal-related issues. Yes, and Heather has no objection to that clarification. However, petitioner Heather notes for the record that as of this date and as of this hearing on December 9th, Will Trabaris has not filed any formal motion to withdraw as counsel of record for Justin Serlick in accordance with Illinois Supreme Court rule. 13C. Therefore, absent such withdrawal, Mr. Trabaris remains counsel of record for the family law case. Additionally, Mr. Trabaris, who was also timely served the bystanders report for Illinois District 2 Court of Appeals, case number, made no objections, corrections, or alternative filings. So even though he was present in the Zoom, and this is happening, even though it's related to the appeal, it's happening in the family law case, he didn't even... he just got, Judge, I'm not representing him in the appeal, but all he could have, he was still the attorney of record.
Right.
You are the attorney of record until you file a motion to withdraw, and you're granted with, that motion by the court. So, if Heather were to file something else in this case, she still has to serve it to him.
Right.
Because he's still the attorney of record. Anyways, let's find some other juicy bits.
Go towards the end because we got to cover this other stuff.
Yeah. Okay, so this is important. The court would only review the portions related to the October 8th, 2025 proceedings. Respectfully contest this limitation under Rule 323C. The court may consider additional proceedings when no transcript is available, particularly given the systematic pattern of procedural irregularities affecting the record completeness. The petition was filed based on something that happened prior, and it was part of this case.
Right.
And the judge is saying, I can't make a decision on that. But literally,
it's not my fault the judges keep changing.
You're the assigned judge for this case, which means you are the judge for the entirety of the case. You are responsible for everything, even though you didn't make the initial earlier judgments.
Right.
If one of your prior colleagues then you're still responsible for making things right. So, court granted Mr. Serlick's 2-619A9 motion based on relinquishment of jurisdiction. Again, if you go just based on the law, the judge was legally required to make findings on whether or not the April 27th order, which is what the contested order was whether the court had jurisdiction to issue it. Beyond that, the court had, without the court first making that determination, the court cannot make any other judgments or determinations in this case. So the court can't simply say, we gave jurisdiction to Florida in September of this year. We're going to completely ignore the fact that she's saying we didn't have jurisdiction before that.
Yeah.
So... Ms. Bend, findings 14 and 15. Ms. Bendel used the Zoom chat. as a last resort because the court
You're
muted her.
violating my rights. What would you like me to do when you're violating my U.S. constitutional rights?
Okay, and then so we mentioned, and this is sort of at the end here, we mentioned the judge sort of threw this little monkey wrench in, and I'm sure this happens to a lot of people who are pro se, and
the technicalities.
This is actually brought up in the
episode 25,
the podcast we were mentioning.
They can deny it on technicalities.
Well, no, but on the judgmental podcast, where you have courts that you can call them secret rules, but they're unpublished, local rules of that particular judge or that particular courthouse. And as a pro se person, you don't always know all of these things, and sometimes they're flat out not published. It's just, all of the attorneys in the area that practice sort of know.
No, but us pro se litigants are privy to
the judge threw this out. Now, this is actually Illinois, statutory law part of this. So under Rule 311, she's saying that she did not personally get served the notice of appeal, and that the chief judge also had to be served the notice of appeal. So the best we found, in researching how to, deal with that, it's a technical noncompliance. And most appellate courts are not going to throw out a case just on a technical noncompliance when it can be alleviated. So once we realized, yes, we missed that little step, we did our best, or Heather did her best. I say we because I help Heather read through stuff and spell check and look over stuff. Heather filed the notices. They were served via certified mail to the judge and chief judge. And Heather also filed a motion with the Second District Court of Appeal, a supplemental certificate of compliance and service under Illinois Supreme Court Rule 311A2.
Yeah.
Basically telling the appellate court, we acknowledge this didn't happen. It was a technical issue because of her pro se status
we'll
and
go
not
over
knowing,
that. That's in here.
And so on and so forth. And then the last, you included a section in your response, specifically the conduct of Judge Jacqueline D. Melius. I'll bet this is what got it. I'll bet she read this and she said, nope, I'm out.
No, because I sent this on the 15th, and that was dated the 9th.
Oh, okay.
But I do want to touch on this. People have been asking me, Malibu Dallas had a Zoom meeting earlier this week where I was in his Zoom, and I was giving people a heads up that you need to put these lower tribunals on notice. And what I mean by notice is when you're filing things, start making subsections that say notice of constitutional violations, notice of state constitutional violations, notice of misconduct on the judges. And I'll explain more of what I just filed along with that.
Yeah.
I put in a whole notice of conduct.
The reason you have to do that in the lower court, the simple reason is that when you get to the appellate court or state Supreme Court, if there's not something in the official written record, they can't look at it.
Right.
So when you put in a specific section that says conduct of this particular judge, and you outline everything,
you can talk about it in your brief.
You can bring that up in your future filings with the higher court. So
yeah. So I basically spelled out how Melius has been treating me since August 12th, my first hearing on that petition. Her denying my court watchers all 4 hearings, her muting me nonstop, violating my due process.
And
then I literally
retaliatory judicial conduct.
Yeah, and I literally put in a whole section of Illinois constitutional and U.S. constitutional violations in this document.
So, and then along with this document, so we'll again get to it. With it, Heather submitted some additional evidence, right? So the
to get
order,
more stuff on the
order
record.
with the findings is the first thing that you gets included.
So Exhibit A.
This was Heather's actual written, what her statement that she read. So now we have the written form, so it's on the record, because there's no transcript or court reporting.
So I'm going to put it on the record myself, because I'm about truth and transparency. The Serlicks are about hiding my children.
You included the documents from the Florida Appellate Court where they were saying they didn't have jurisdiction.
Here's the thing. I had already gone through Florida to try to deal with this 3-page void order that Illinois wrote. And Florida Appellate Court literally denied my notice of appeal, saying we didn't write this.
To vacate it.
We didn't write this. We don't have jurisdiction to vacate it. Yeah. So where else would I go?
You'd have to go back to the original court.
Back to the court that signed the order. So that's what I did July 17th.
And then they turn around and say, well, we don't have jurisdiction.
Right. We gave jurisdiction to Florida. So here we are, Florida saying, no,
run in a circle.
It's Illinois' jurisdiction. Illinois is like, nope, it's Florida's jurisdiction. And when you get stuck between two states that are pushing you back and forth, then to federal I go.
There's some interesting thing along with the Florida Appellate Court paperwork. There was some stuff that you filed with the Appellate Court. It's different memorandums of law.
Yeah.
But you also included, with this particular filing, your response, you included a copy of the bystanders report. That's the uncontested bystanders report.
Uncontested. He never responded.
And then... let's see.
Hear that, kids? Your father never responded to my bystanders report.
Proof of service.
Which means he's admitting that what I wrote on that bystanders report is accurate because he never responded to me. He never contested it. Ariana, Tommy, Bianca, Charlie.
Something else we did because I was a witness to the Zoom hearings that occurred in Circuit 19. I kicked my mic stand. I wrote up an affidavit. Basically, it's a witness statement.
Since I couldn't have court watchers that could do affidavits for me, he did one for me.
Signed and sworn and notarized and filed, and it's a factual, accurate statement. I'm not gonna put myself on the hook for making anything up or lying. I mean, it's everything in there was factual, what I witnessed. Yeah.
So along with that response, I also filed. I bet Michael G. Nerheim appreciates this. Notice of judicial misconduct and material facts regarding Judge Michael G. Nerheim's involvement in related proceedings.
And you actually filed that with both Circuit 19 and the Appellate Court.
Yep. I filed it in both. Now, earlier this week, I had posted on my Facebook just the very top page of each of these. So now I'm actually explaining that sneak peek that I gave earlier this week.
And just to recap anybody who might be new here, who's Michael G. Nerheim?
Michael G. Nerheim was the state attorney that was in charge of investigating and charging Justin with child abuse in September of 2020 after my children made written and recorded statements to what Justin Serlick was doing to them. And then all of a sudden, 2 weeks later, my children were kidnapped from their daycare. Michael G. Nerheim lost the 2020 state attorney election to Eric Reinhart, and then in 2021 was appointed by the Illinois Supreme Court to Circuit 19 as a judge instead. He has never been a judge on my case.
That's what I was about to ask.
The only involvement was he was the state attorney involved with investigating and charging Justin Serlick with child abuse.
But if he was never a judge in your case, why are you filing a notice of judicial misconduct against him as a judge?
Well, it goes back to exactly what I have been talking about pretty much since I started this podcast. He had reached out to my attorney here in Florida.
Ex parte communications.
Ex parte communications.
Violation UCCJEA.
Yeah, he had reached out to Mary Jane Nettles, my attorney here in Florida Circuit 7, to pass along his private cell phone number to the judge here in Florida, Judge Stasia Warren, and Justin's attorney, Serena Baldacchino of Rice Law Firm in Daytona. How did I find out about this? Well, a little bird told me to file a public records request with Mark Weinberg of Florida Circuit 7. Mark Weinberg gave me a very interesting file file that was missing at least 9 months of communications.
Oh, it was blatantly obvious. It was not all of the record.
It was missing all of Mary Jane Nettles. So I
filed a request for them to double check.
Right. I emailed Mark Weinberg back and I said, you are withholding information. Florida has what's called the Sunshine Law. I have the right to all documents that are involving my case.
Yeah, when I say it was a request, it wasn't so much a request as it was, you are violating the law. I will hold you accountable if you don't figure your stuff out.
So I get an email from Florida Circuit 7's attorney, Joshua Griffith, saying, I hope this message finds you well. My name is Joshua Griffith. Now, the date of this, just for time, is January 7th of 2025.
Just for anybody that didn't catch that, because it went pretty quick, this is from the attorney that represents the actual court.
Circuit 7. Yep.
The general counsel for the court.
7th Judicial Circuit of Florida. Okay. So this is dated January 7th of 2025. So as of January 7th, 2025, I now know exactly how all of this shit has been playing out the way it has. I now know why I haven't been able to get anywhere in Florida with this 3-page order. Because I was provided by Joshua Griffith a ex parte email that Mary Jane Nettles, my attorney, dated Friday, January 26, 2024 at 5:34 p.m. to Leslie Pomar, who is Stasia Warren's judicial assistant for Florida Circuit 7. And Serena Baldacchino, Justin Serlick's attorney for Rice Law Firm. She's memorializing that Michael G. Nerheim called her on his private cell phone number, requesting to pass along his private cell phone number to Judge Warren and Serena Baldacchino.
And she felt the communication, the phone call was so inappropriate, she felt the need to CYA and put that email to the court. Now, the interesting thing is that email was never docketed. It was never actually filed into the record.
No. So many laws are being broken. So I then turned around after taking a few days to digest what I had just realized and learned. I knew as soon as I saw the email, Michael G. Nerheim's involvement as the state attorney to investigate and press charges on my ex-husband for child abuse. I knew this was all sorts of collusion and corruption.
Backroom deals.
So I have known since January 7th of 2025, so a full year now, I have known that the Serlicks are paying off people to hide my children. And now I've got evidence for federal court to sue everybody. So I then documented in an emailing Mary Jane Nettles, and I've read this on previous episodes, so I'm not going to read it again, but this will be in the Google Doc for you to read. But I basically memorialized on January 11th of this year, Mary Jane Nettles, you broke laws, you violated laws, you are you are the cause of a lot of what's been happening here in Florida. You need to fix shit. And of course, she never responded to me, but she will be a defendant in my federal lawsuit against everybody here in Florida. So then I also filed that exact same thing in Illinois District 2 Court of Appeals. So that is also in District 2 for the notice of misconduct. So they can't say they didn't know about it, but it also means this will be in my docket to be sent over next week, so I can write about this in my initial brief.
Part of the reason we put it on record and why you filed it in Illinois
there's
District 2 Court of Appeal is so that if by chance Judge Nerheim calls up, one of if they're all buddies and all play golf together, go sip bourbon at the country club, whatever. Any of the judges in District 2, they're hopefully going to think twice before talking to him.
Because it's on the record. I'm literally calling them all out on their illegal activity.
Yeah.
So the more people that continue with the illegal activity, the more defendants I get to list on my U.S. District Court complaint.
Filing the notice against Nerheim in District 2.
Yeah.
Get some more eyes on it. But again, it was a preemptive, sort of defensive move on your part.
It's just, I'm going to put everything on the record. You guys want to keep everything off the record. Well, these are my children I'm fighting for, and they need help. My daughter
really do.
Bianca currently has a 1.0 GPA for the third year in a row in Justin Serlick's care.
I mean, this is what family court does. They sit there and say, well, another court made a decision. We can't change it because we don't determine that there's been enough of a change.
Yeah.
So we're just going to continue to let these children suffer and fail completely out of school.
Yeah. Well, my children, 2 of them are already of age. 2 of them are now adults, and they absolutely have a federal civil rights case against Illinois and Florida. So Ariana and Tommy, I hope someday you actually fight for your constitutional rights that were violated the last 6 years. But I'm basically setting this up so my children can go after these people in federal court as well, because they have every right to as a victim of this. And then, as Pete previously mentioned, I did file a notice of supplemental certificate of compliance and service under Illinois Supreme Court Rule 311A2. So this is me telling Illinois District 2 Court of Appeals that I have served. The moment I learned about this rule that I have to serve Melius and the chief judge, I did exactly that. As soon as I learned of my error, I fixed my error. And that's why the other day I posted photos of 3 packets two being sent to chief judge and then 1 being sent to Melius. Because I also sent the chief judge the notice of misconduct of Michael G. Nerheim as well. So that is that. And then this is pretty much all that copy. And then my notice of judicial misconduct in Illinois District 2 Court of Appeals. And then finally, we get to the end of that. Yesterday, I got because I paid the invoice.
Going back a couple steps here, just to bring everybody back up to speed. You had to pay Circuit 19
for my record on appeal.
Basically for them to email or mail a copy of the docket.
Electronically send over a copy of the record on appeal up to November 21st. But she knew that I was trying to deal, the appellant clerk knew that I was trying to deal with the bystanders report. So I told her there's going to be more documentation that needs to be sent in before the deadline of December 24th because I was granted this extension. She's like, that's fine. Just tell me when you're ready. I'll send you a new invoice. So yesterday afternoon, she did send me a new invoice for everything from November 21st to current. And so that invoice is for a total of $35.50 for 142 pages. Yep. So in total, I paid $346.25 and then $35.50. So almost $400. $400 just to get my docket sent over to Illinois District 2 Court of Appeals.
This is essentially one of the ways they gatekeep people who don't have the financial means to continue to fight.
Yep.
It's
not everyone has $400 in their account to pay for this record.
You and I both have good jobs, and we're able to at this point. But you certainly went through hell the last few years, and there were absolutely times when you couldn't rub 2 pennies together.
No. So. I didn't even know where I was going to be living the next day because I was struggling to find housing down here because of, there's a housing boom here. It's super expensive to live in Florida. I had to resign from a job just to move down here because the only reason I was remote for that job was because of the pandemic in Illinois. They don't allow remote work. So when my children were shipped down here in 2021, I actually had a job that I had to resign from because they wouldn't allow me to work remote in Florida.
No, they wanted you to go to, was it Austin, Texas, or
no? That was Capital One.
Oh, sorry. You were already down here.
Yeah, I was already down here when I started at Capital One Service Desk. So I did file, just like I said previously, with the first invoice, you have to write a little correspondence. So I wrote that today, and then paid the $35.50 today, and e-filed it. So that is all good. So that's literally where we're at with Illinois. So that means that my Illinois docket, all of this we just explained to you, all of this has to be sent over. It's now covered and paid for in full. Has to be sent over. The deadline is December 24th. So that is next Wednesday. So Illinois Circuit 19 has to get my entire docket from 2013 all the way to current sent over to Illinois District 2 Court of Appeals. And then next is the appellant brief. Because this is an accelerated appeal, because it involves custody or care of children, the appellant's brief is due 21 days after the record on appeal is filed in the appellant court. So that means that my initial brief is due 21 days from December 24th, which calendar based on that pretty much lands it on my birthday, January 15th of 2026. And then the appellee's brief is due 21 days after the appellant's brief is due. So that will push it to sometime in February. And then I have 7 days to respond to his. Now, my last 3 appeals in Florida District 5 Court of Appeals, he's ignored all 3. So I don't know. I don't know what he's going to do to fight this pro se, but the law is on my side. The docket is on my side. I will be calling out the docket manipulation. I've already called it out. It's in my record on appeal, so it's going to be written into my initial brief. The docket manipulation that you have been pulling, Mary Serlick. You guys think that you're so damn smart, and this whole time, for 5 years, I've actually been setting you up for a civil rights lawsuit.
Yeah, it's interesting, you know, as we literally have, you know, your docket from Illinois printed out, you know, as of certain dates. So we have like the full docket. So there's a, you know, cover sheet that shows everything that's listed, and we have all the documents listed, everything printed out, and then after the fact, we'll look at your docket again, and there's like new documents that have been added and post-dated or pre-dated, just as if they were there the whole time, but they weren't.
I happen to notice, Tori, have they unsuspended your license, Heather? Sorry if this is something that you've answered. So last week, I actually put out a bonus podcast episode where I went to the Daytona Child Support Office, and they did confirm that because my teacher salary is being garnished at 60% currently, Justin Serlick is basically stealing from me while holding my children hostage. Because it's currently being garnished, they are not suspending my Florida driver's license. And that's what I was so PO'd about, is how the F can they threaten to take my driver's license when they're currently stealing 60% of my teacher's salary since September.
And then not only that,
so
you received the letter before it was even, you received the letter before it was even dated. And when you were at the Department of Revenue to question all this,
it was fixed 5 days prior to that.
Fixed before the letter was even
so
written.
To my
crazy
knowledge,
that they get away with this stuff.
Yeah, to my knowledge, my Florida driver's license was never suspended and will not be suspended. So thank you for asking, though. But yeah, guys, this is why so many of us are fighting for Title 4D reform in Washington, D.C. with Mark Ludwig, because this is all possible, that they can randomly throw you in jail on child support arrears and try to or will suspend your driver's license, because it's all linked to Title 4D.
Yeah, basically lets, you know, the state throw it over to a state agency like the Department of Revenue to enforce, but then that state agency it removes a bunch of your due process
and then they
rights.
Unconstitutionally
and so
jail you or suspend your driver's license, so you can't go to work, you can't have a life.
Specifically in your case, when you were in the you know, child support hearing, you know, with the child support hearing officer who's not a judge, they're, I guess, akin to a general magistrate here in Florida.
Right.
When you brought up the fact that they don't actually have jurisdiction to enforce this in Florida because it was the order was never registered under the statutes for child support enforcement, they're like, la 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 la, we can't hear anything.
Right.
You know, the judge already made a decision, but these were new. The reality is these were new arguments at the time because we had just realized the deficiency.
Yeah. All right. We are almost at an hour and 20 minutes. We had to cover almost almost 3 months worth of court documents.
I'd like to point out one thing. Again, all of this stuff occurred. Can you raise your right hand and swear on the broken wrist? Yeah. Heather got all of this stuff taken care of with a broken wrist. That she's been in a cast for the past month. And
thank God it's coming off on Monday. I hope it's supposed to be. They can't x-ray it without it, so it's got to come off. But yeah, Monday it's been 6 weeks. November 6th is when I broke my arm at work. So hopefully it comes off soon, and then I'm really going to get to work, because this is just, a lot of this has been Pete helping me type. He's sitting next to me typing while I'm basically dictating what I want him to type, because it's just so incredibly hard to angle my hand right without the cast pressing on my ulna while I'm typing.
Or hitting the power button and shutting your laptop down.
Shutting my laptop off while I'm grading, yeah. So I want to end on the very last thing. So I have ventured into something called LegalShield. And I have a website that you can go to. The link is on this live.
And I'm going to pull it up so anybody can take a look. We'll put the link in the note.
So if I have a legal question, if I need a document reviewed, if I need a letter written up on my behalf, they are there for me. And it is not as expensive as you think. Yeah. And you can do two options. You can either just buy the services so you have them, or you can venture into starting your own business with LegalShield as well. If you are interested in looking into it further, please go to my LegalShield website, heatherbendel.legalshieldassociate.com.
If you're watching the video of this podcast, just go ahead and take out your phone. You can scan the QR code that you're seeing on the screen right now.
I'll take you right to my website. Take a look at the different plans and all the different cool things. I just did training this morning. That's why I did not. But also as some side supplemental income. I am a public school teacher, so I have summers off. So this, I'm working on becoming a certified paralegal. So this will absolutely complement what I'm trying to do with my Justice for the Serlick Children nonprofit, where I'm helping other litigants with their documents. I'm, showing them how to e-file, etc. I just think this is going to be a great service addition to what I'm already doing. So definitely take a look at that. Again, I will give more information in a completely separate podcast episode, but just a few of the flyers that I have. A law firm in the palm of your hand.
Remember, watch out for the logo.
They have an app.
Behind the logo.
Oh, sorry.
Look at the screen. There you go.
They have an app, so you literally have it in the palm of your hands. Have you ever wanted business legal advice, needed document review, been concerned about lawsuits, needed help with debt collection, had questions related to your employees? Smart, simple legal plan coverage starts here. Real lawyers, affordable access. Okay. And then one of the other ones, don't let your legal question become your legal problem. Request a consult. Legal advice for every stage of life. Trust versus will. So, Pete, how much did you pay for your trust?
So and I did it the cheap way. I used one of the online services, which it was, I've at this point used both LegalZoom and trustandwill.com for estate planning documents. And, it was good for somebody who's sort of tech savvy, knows a little bit about it. It was fine, but it cost me $500 to prepare my trust and estate documents for myself. LegalZoom was about $200 for just a will and life end of life planning.
Are you
documents.
talking about this?
No, legal. Sorry, not legal.
You said LegalZoom.
Yeah, LegalZoom. So that's I used LegalZoom for preparing mom's will and power of attorney and
Gotcha.
Medical proxy.
So if we had
trustandwill.com for me was $500.
Yeah, if
so I
we
spent
had
$700 on
if we
estate
had
documents.
this, how much would it cost you to do?
$250.
Yep, through LegalShield.
And
they do it for you.
Yeah, and that's only one of the many benefits that we have since found out about. I do want to just make it clear: LegalShield is not, you are not contracting an attorney for it. It's a subscription for access to their services.
Right.
If you do actually need an attorney,
you get a discount off the retainer.
I think it's 20%.
25.
Sorry.
Yeah. 25. So you're not paying to have a law firm represent you. You're paying for on-demand specific services when you need them.
Yeah.
And there's no limit to how many times you can ask them legal questions. There is a limit on how many legal documents. So like every legal document you need reviewed, they will review at no charge up to 25 pages. So like my bystanders report, they could have reviewed that and it wouldn't have cost me anything extra. And then business card. So like this is just a sample, but you can keep this business card on you at all times. And it says law enforcement officer or security personnel. If it is your intention to question, detain, or arrest me, please allow me to call a lawyer immediately. And then the info for your website would be at the bottom. So you basically give the officer or whoever is, basically looking to detain you, you basically give them this card and it says my legal rights are protected, 24-hour hotline for covered emergency situations. If injured in an accident or arrested or detained, call blah, blah, blah.
Yeah.
Okay. So
it's basically like AAA, but for any legal issue you may run into.
Yeah. I also got the add-on ID Shield, so it's constantly monitoring my 3 credit reports. It's also monitoring the dark web. So anytime my emails are compromised, you put in your emails, your phone numbers. Anytime any of that is compromised, it alerts you immediately. Yes. So with the day and age of fraud happening
it's
and
important.
Cybersecurity,
you can't just rely on your bank or credit card to let you know when something went sideways. It really is important to take proactive steps. And so this is just one of those proactive steps.
So I just started with LegalShield this week. So obviously I'm brand new to it. I'm going to educate myself more, do more training, and I'll continue to share my knowledge. I'm also going to be utilizing them this week. So I will also share my experiences with you guys. But definitely take a look at this. If you're pro se or you're concerned about CPS showing up at your door, there's so many ways that you can utilize this service, and I absolutely will be.
And we're utilizing it. Basically, you get as since we're together living in the same house, it covers both of us.
Right. So he has access to all the services that I have. So for the same cost. So it also covers if you have dependents, they have to meet certain criteria. Your dependents are covered, spouse, domestic partner, they're covered. So guys, I definitely would suggest it's worth taking a look at least.
Yeah.
If you can't afford it right now, maybe you can afford it next month. But definitely go to my website, take a look at it, look at what the options are. If you've got a small business, there's an add-on for small businesses. There's so much.
They'll take care of you. You can get was it 2 or 2 traffic tickets per year? 2
traffic tickets a year.
Taken care of at no extra cost.
No, it's just included in the plan.
So.
Yep. So on that note, on that note, now we are now officially caught up with everything that has been happening. My wrist injury has caused us to fall behind on the podcast, so I wanted to get everyone 100% caught up before Christmas. The very next step is the December 24th, Illinois Circuit 19 has to get that record of appeal sent over. So I then have 21 days from December 24th to get my initial brief filed, which I, of course, will be doing. But other than that, I have not done anything in Florida Circuit 7 since I got this new judge. I absolutely will be in the coming weeks. So Justin Serlick, keep a lookout for that because I'm coming for you. You're not going to be able to hide from me forever. You're not going to continue hiding my children from me forever. 2026 is the year of U.S. District Court, and I am super excited to list out over 30, 40, who knows, it could be even 50 defendants in my Illinois U.S. District Court, 42 U.S.C. 83, 85, and 86.
And just something I want to point out, because, for anybody who's sort of new to all of this, it may seem like, blowing smoke a little bit when you're saying you're going to file federal lawsuits, but we're actually seeing with other people we've connected with, that's exactly what they're doing. So this is not like Heather's not just coming up with this idea on her own. This is what people who have been harmed by family court across this country are starting to file federal lawsuits against the judges, the guardian ad litems, the friends of the court, the private agencies like Camelot Care in your case, because they all conspired to violate your rights.
Yeah. The moment you recognize, and Malibu Dallas talked about this in his Zoom last week, the moment you recognize that your constitutional rights, state and federal constitutional rights are violated, get in federal court. Like, I should not have waited as long as I did. But because I waited, I've now got boxes of evidence to prove they're violating my children and I's constitutional rights. They conspired with the Serlicks. They absolutely took money from the Serlicks. This is... At some point, the FBI needs to investigate my case. Someone needs to investigate it because the amount of felonies that these people have committed to hide my children from me in Daytona, Florida is disgusting. And I'm going to continue to expose it. So that's where we're at. Guys, if anything I'm talking about resonates with you, if your situation sounds similar to mine, let's get in federal court. Let's just all start. 2026 needs to be the year of fighting for our constitutional rights. Let's get in federal court. Let's serve these people with U.S. Marshals. Let's show them that we, the people, are no longer going to allow these public officials to trample our constitutional rights that our ancestors and our forefathers fought for, including my grandparents. So on that note, have a great night, everyone. If I don't see you guys before Christmas, have a Merry Christmas.
Merry Christmas.
Bye.